Hey, I'm estate planning attorney Paul Rabelais, and in this video we're going to talk about who you should name as the executor. So I've either prepared or overseen the preparation of probably about 10,000 wills or so over the last 3 decades. In every single will that I've either prepared or oversaw the preparation of, there was an executor named. Some people get hung up on their executor decisions. So in this video, we're going to talk about the things that factor into and the things that may keep you from getting hung up on naming an executor. All right, so the first thing I want to do is I'm going to talk about who typically is named as executor, but you may not have typical circumstances. So after we talk about what's typical, we'll talk about the roles of the executor, and hopefully by the end of this video, you'll have a really good idea of who you should name as your executor. All right, so what's typical? Well, if you're married, it's typical that you name your spouse as the executor. If you're not married and you have adult children, it's typical that you name either one of the children as the executor or 2 or more children as the co-executors. More on that later. If you have minor kids and you're married, you'll name your spouse as the executor, and then you'll name some other, perhaps relative, mother, father, sister, brother, as the alternate executor. If you have minor kids and you're not married, well, again, you might name mother, father, sister, brother, some other trusted friend or relative as the executor. So that's what's typical. That doesn't cover every circumstance. So now let's talk about what the role of the executor is, and that might help you make the right decision. Okay, so the role of the executor, sometimes when somebody dies, sometimes their accounts are frozen. No one can access that. So it's the executor's role typically to hire a lawyer, and we go through a process to get a judge to declare that the will is valid, and we get a judge to sign a court order confirming that the executor is now confirmed as the executor. Courthouse issues these, I'll call them court orders. And what that does, that allows your executor to go, if necessary, set up an estate account at a bank or a financial institution. And it allows your executor to go collect the funds from those accounts that were in your name that are now frozen and kind of pool all those funds together into the estate account to cover your mortgage if there's a mortgage, your car note if there's a car note, any other expenses that come up while this stuff is going on. Note that the executor role is really a temporary role from the date that you die or the date they get confirmed as the executor until the succession or probate matter is complete and the assets are ultimately dispersed, to the appropriate heirs. Sometimes the executor will need to sell something that's in your name after you pass away in order to make it easier to settle the estate. So sometimes we see the executor selling the home of the person who passed away, selling the vehicle of the person who passed away. So the executor has that role as well. So but I see way too many people get hung up on who they're going to name as the executor. I see a lot of parents sit across the table from me and say something like, "Oh, we have 3 children. We don't know who to pick. We don't want to offend our daughter if we pick our son." Or we really like our son-in-law. He's really on the ball, but we don't want to offend our 2 sons by picking our son-in-law. So those are just personal decisions you've got to work through. For example, if you have 3 children, do you name 1 or do you name 2 or 3 of them? I will say in general, it's easier to get things done if there's 1 executor. But if you must name 2 or 3 co-executors, by all means, that's certainly a possibility for you. What I find is when parents are getting hung up, when they have adult children, they don't know who to select. Of course, they'll name each other first. They just don't know who to select as the alternate executor. They might decide to go talk to their children about it, and parents are hung up on it. Parents go talk to the kids. We're trying to get our estate in order. We don't know who to pick as the executor. We wanted to talk to you. Usually when those parents come back to me, I say, hey, did you talk to your kids about some of these decisions? And the parents will say, yeah, they just said, heck, do whatever you want to do. It doesn't matter to us. So I think the parents put more thought than necessary and get a little hung up, sometimes more than they need to. But just kind of force yourself to make a decision. And if appropriate, talk to those potential heirs and potential executors about it. And usually I think you'll find that they're very, very supportive of whatever decision you might make. And if you communicate it to them, then it's not a surprise later on, and usually things go smoother because there is no surprise. Note that you can always change it. You know, if you change your mind, or if something happens to one of these executors or alternate executors that you named, then you can always, you know, change your will. Note that the executor has zero discretion to change how things go. You know, if you wrote in your will, I leave $10,000 to St. Jude Children's Hospital in Memphis, and I leave everything else to my 3 children equally, and you name your son as the executor and you die, your son can't go in and say, you know, I'm going to bump up that $10,000 bequest to $25,000. And instead of leaving everything else to the 3 of us equally, I think my sister should get a little more, so, you know, she'll get half, and me and my brother will get 25% each. An executor can't do anything like that. So their role is to just, you know, make sure that your intent, you know, gets fulfilled. Sometimes people get the executor role confused with other roles that you'll be designating as part of your estate planning legal program. So sometimes people get executor confused with power of attorney. 2 completely different roles. Power of attorney is who you designate to handle things while you're alive, but you're unable to handle things for yourself. You can't sign your name, accident, illness, injury at some point during the rest of your lifetime. And then that person you designate on your power of attorney will have that ability to be able to do things for you. Now, the same person may fill both roles, but it's 2 different roles. The executor handles things. The executor has no authority to handle things before you die. They handle things from the point that you pass away, or at least when they're confirmed, until, you know, the matter is complete and all of the assets have been dispersed to the heirs. It's a temporary role. And then some people get executor mixed up with trustee. So when you leave assets to a trust, or there are assets in a trust in your name when you die, it's that trustee. Again, may be the same person as your executor and your power of attorney, but your trustee, that could be a role that could last for a while, especially if you have minor kids and you pass away and, God forbid, your children are 6. Well, that trust that you leave things to for your young children will likely be in effect for many, many years, maybe even decades. So that trustee will fill that role to manage the trust assets until the trust terminates and assets are distributed to the trust beneficiaries. So you got a few different roles there. One other role is that guardian. Again, this is if you have minor kids, you'll designate guardians or backup parents to your minor kids. That's a different role from the executor. Can be all the same people or can be different people. So I hope that helps in you making a determination of who your executor and your alternate executor should be. Sometimes an attorney is named as executor, but it's not typical. I mean, I've been an executor a couple of times over the years. I remember one in particular where a divorced father had 2 daughters, and he had his reasons why he just didn't want either or both of his 2 daughters to be the executor of his will. And he had nobody else. He was retired. He was going off to kind of live out of his RV. He had no other family. He had no other trusted friends or relatives. And so in unusual circumstances, we'll see people designate perhaps an attorney or an accountant or some other professional, but it's not typical. All right, so hope this helps you make that decision. Make sure you subscribe to my channel here on YouTube and hit the notification bell so you don't miss anything. A thumbs up would be awesome. Comments about your experience either as an executor or naming an executor are always welcome. Y'all have a good day.